Hi friends and a very warm welcome. Today's video session we are going to be discussing a very important fundamental right, and that is Article 22, which talks about protection in respect of arrest and detention. Now friends, we know that Article 21 very clearly mandates that no one is going to be deprived of his life or personal liberty except by way of the procedure that has been established by law. And an individual's personal liberty can only be taken away when he has been lawfully arrested or he has been lawfully put under preventive detention. Now, friends, you can be arrested or detained only under two circumstances, or I would say that the law can only deprive you of your personal liberty under two circumstances. That is when you have committed an offense, and in this situation you will be arrested, or when there is a reasonable suspicion that you are about to commit an offense, and in this case you will be put under preventive detention. Now we are going to begin our session by first discussing what are the rights that are available to an individual when he or she is arrested. So friends, we are going to begin this session and we'll first understand that I want all of you to visualize a scenario that when police authorities approach you and they tell you that you're about to be put under arrest, then what are the rights that are going to be available to you. So students, first of all, your most basic or foremost right is that you have to be intimated about the grounds of arrest. That is the reason as to why you are being arrested, why you are being taken away by the police authorities, or why you are being deprived of your personal liberty. This has to be made very clear to you. So let's take an example. If someone has leveled a charge of murder against you, so when the police authorities they approach you to arrest you, they will have to convey to you that they have an arrest warrant and these are the charges that have been leveled to you. The next and the most important right that is available to you is that you have the right to consult an advocate of your own choice, and not only consult but also you have the right to be defended by the lawyer of your choice, because legally a lawyer can represent you in such matters most effectively. So you must be given the freedom or you must be given the leverage or space to hire an advocate of your own choice. Thereafter, the next important right that you have is that the minute you have been arrested, starting from that time, the minute charges have been leveled against you or an FIR has been lodged against you, or the minute you have been put into the lockup, so your time period for arrest will be counted from that minute. So starting from that minute till the next 24 hours, within that time frame you have to be produced before the nearest magistrate. Now there may be a situation because the police authorities might arrest an individual at a place which is cut off from the rest of the civilization due to a heavy landslide or snowfall. So it might take them, due to this difficulty or obstacle, it might take them more than 24 hours. It might take them 3 days to reach the nearest magistrate to produce the arrested individual. So in such circumstances, the law clearly says that the journey time will not be included when we calculate the time frame of 24 hours. Now the next thing is, if an individual has to be detained beyond the period of 24 hours, there has to be an express authority given by the judicial magistrate. So it is interconnected with the right where an individual has to be produced before the nearest magistrate within 24 hours. And once the individual has been produced, then it is the judicial magistrate who will apply his power and discretion in deciding whether the person must be kept under an arrest or whether the person should be set out on bail. So in case a person is detained beyond a period of 24 hours where there is no reasonable cause to do so, then that period beyond 24 hours will amount to a period of illegal detention. Hence, the authority to detain an individual beyond 24 hours can only be given by the judicial magistrate. And finally, as the last point on the slide tells us, we are going to discuss that These rights are available to most of the individuals, but we have exceptions. And what are those exceptions? Well, the first exception is that all these rights that I have just discussed with you are not going to be available to the citizen of a nation who our country has expressly declared as an enemy state. So any citizen of that country who we have declared an enemy state is known as enemy alien. So these rights will not be available to that person. And secondly, these rights of being informed about the grounds of arrest, of not being detained beyond 24 hours, will not be available to those individuals who have been placed under preventive detention. And Article 22's second part clearly deals with the aspect of preventive detention. So let us proceed in this video by discussing what preventive detention is all about. Now, what is the difference between arrest and detention? Now, arrest is punitive in nature, and preventive detention, as the very word tells us, is preventive in nature. Now, as I mentioned in the beginning of the session, that once you have committed an offense, you are going to be arrested. So it is a punishment, or it is the first step towards punishment that follows after you have committed a crime or an offense. But detention is a preventive measure, and once there is a reasonable suspicion that you are about to indulge in an act which is about to affect the security of the state, or which is going to interfere with the maintenance of public order, or which is going to affect the foreign affairs of our country, or which is going to interfere with the supply of essential goods and services, or the defense sector of our country, then in these situations the person can be put under preventive detention. Now, when we were discussing arrest, we brought one thing to the forefront, that you cannot be detained beyond the period of 24 hours until and unless you are produced before the judicial magistrate, who can then authorize your arrest beyond that period. But the maximum period of detention is 3 months. So now you can see how there's a huge difference when we talk about the time frame as far as arrest is given and as far as detention is considered. Now there is a provision for the constitution of an advisory board. Now this advisory board will consist of people who are either judges of the High Court, or those who have the qualifications to become the judge of a High Court. And these people consider, and in addition to considering the grounds of detention, they also comment on whether this detention is required or not. So they not only consider detention, they also see whether it was justified or not, and then they will present a report on such detention. Now, the person who has been detained, he has the right to make a representation against such a detention, and this opportunity should be given at the earliest possible time. So a detainee will be given the earliest opportunity to present himself before this advisory board, so that he or she can make a representation against such a detention, and then the advisory board can consider whether this detention has to be extended beyond 3 months, or it should not even finish the period of 3 months. Clear? Another thing that is really important is that once it has been very strongly recommended that this period of detention from 3 months should be brought down to 2 months. However, it has still not been applied, and India is still carrying forward with the time frame of 3 months. Now, another important thing is that as far as arrest is concerned, you were allowed to question the grounds of arrest as a matter of right. But When preventive detention is the case, then you cannot claim to know the grounds of arrest as a matter of choice, because I've already explained that a person is mostly put under preventive detention when the security of the state is involved, or the maintenance of law and order is involved, defense or foreign relations are involved. So in such a situation, it is not always advisable or right to disclose the grounds of detention. Hence, the disclosure of grounds of detention is not a right as far as preventive detention is concerned. Another thing is that this period of 3 months has been laid down so that there is not a scenario of indefinite detention. Okay, so every 3 months there is going to be a revision, is what I mean. So if a person's detention is extended beyond a period of 3 months, then the advisory board will reconsider whether this extension is justified or whether another extension has to be given. But there will be reconsideration of detention orders every 3 months. And finally, what are the exceptions? Now, Article 22, Clause 7 lays down a very important thing, and it says that the Parliament can come up with a law which can change this stipulated 3 months to a longer time period also. Having said that, the law also says that even though it can extend this period of 3 months, but at the same time it will have to again lay down an upper limit. So if they extend it beyond a period of 3 months by laying down a new law, that does not mean they can create a provision for indefinite detention. They will still have to lay down an upper limit. So let's take an example. If by law the legislature lays down that the period of detention will be 9 months, so they will have to come up with an upper limit where they say, okay, the minimum period will be 9 months, but it cannot exceed beyond 14 months. So something like that. So friends, with this we have come to the end of Article 22, which can be very easily called or summed up as the fundamental right of arrested persons or detained persons, because it is specifically focusing on those people who have either been arrested or detained. So it's very essential that how the constitution makers have kept in mind that even those people who have either broken the law or who might break the law, even their basic rights must not be interfered with. And Article 22 was a very honest attempt to ensure that they do not face an unjust trial or an unequal trial. So friends, with this, I'm going to conclude the session. We will look forward to your feedback and queries. Thank you so much for your time and take care.